children matters, family breakdown, and financial orders. We focus on all aspects of immigration law. Our areas of expertise extend to visas for individuals and businesses. These include spouses, students, visitors, EU applications, investors, and more. We also undertake appeals and judicial reviews of negative decisions. We hold Law Society Quality Mark in immigration law. Our family law solicitors are dedicated to finding the most effective and pain-free resolution for our clients through the provision of sensitive, effective, and affordable legal advice. We are also Ghanaian law specialists and have advised many local authorities and other solicitors on aspects of Ghanaian law. We have also advised businesses looking to relocate to Ghana. Our senior partner is dual qualified as a barrister at law in Ghana and solicitor to the Superior Court of England and Wales. Client satisfaction is our number one priority. This shows in the number of positive reviews we have received from our clients. BWF Solicitors, your preferred community lawyers.
Welcome, ladies and gentlemen. You are welcome to the Legal Hour with BWF Solicitors. Today we have our learned resource person. She's a partner at BWF Solicitors and also a seasoned solicitor at BWF Solicitors. This program is brought to you by BWF Solicitors as well. Today we're going to discuss child arrangement orders, having access to your child when your relationship breaks down. So let me, without wasting my time, introduce Mrs. Eunice Achampong, lawyer at BWF Solicitors. Welcome, Eunice. How are you doing?
Thank you. I'm doing very well, Vicky. Hope your week has been good.
Yes, it's been very, very good, and looking forward to today's topic as well. Every Saturday at this time, I always look forward to what we've got in store for our viewers and listeners. Ladies and gentlemen, if you want to contribute to the program, do not hesitate. Go to our Facebook page at BWF Solicitors, Vicky Newton, and you will be able to send your messages for us to put them up and discuss it. If you are not comfortable with sending messages on Facebook, you can call me live on mobile 0744 8619 711 0744 8619 711, and I'll be able to pick your call live. Lawyer Eunice will be able to answer your questions. Please share this program to all your contacts on your list, loved ones and colleagues, for them to also join in the discussion. So, Lawyer Eunice, any updates before we get into the topic?
Okay, so in terms of our updates, a lot of our students who are international students in the UK will be very aware that there is the graduate scheme opening up on the 1st of July this year. And I think it's wonderful news that a lot of them, having studied and completed their course, will now have a means of staying in the UK for an extra 2 years, or for PhD students an extra 3 years. And so not long to go, the scheme will be opening up on the 1st of July. And so, of course, our students can look forward to applying to extend their leave in the UK. The normal application fee of $700 will be applicable, and then they will have to also pay the IHS for the 2 years which they will be given. And so, of course, during that time, if they want to switch to any of our worker routes, such as the skilled worker route or the health and care worker route, or even the innovator startup business routes, all of the other routes are available for them to apply to whilst in the country for that 2-year extension. So that's something good to also look forward to. So I just wanted to inform people and let them know that this will be starting on the 1st of July, which is a few weeks' time from now.
Oh, wonderful. Great. Okay, so Lawyer Eunice, child arrangement orders. Why this topic today?
So it's interesting because somebody else said that when I put it out for our Thursday program. And of course, I think that this is something that is also common in terms of relationship breakdowns. And so when that happens and you want to have access to the child, and one party is saying, well, there's nothing between us, I wouldn't allow you to see your child or your children, then it becomes a problem. And if you are not somebody who is firm enough, you might be bullied by the other party. And unfortunately, this is what happens in most relationships that break down, and the other party prevents the other person from seeing the child or the children when that happens. And it shouldn't be that way.
Yeah.
Things can be done amicably, but it is not always the case. And so if the other party is not cordial or is not trying to do things amicably, then you might as well look at other means through which you can also have access to the child or the children that you both have together. Yeah.
Great. So can you take us through the process, what the
Okay.
child arrangement order, the process?
Okay, so when we talk about a child arrangement order, usually it is an order that is under our law, which is our Children's Act of 1989. So within that, you are saying that you want the court to grant you access to your child, and usually once a child arrangement order is applied for, you are saying to the court you want the child to either live with you or to spend time with you, or the time and how much of the time that the child should spend with you. Um, as it is, most of the time, children will usually be with their mothers. And so usually the main culprits will be the fathers, and how the fathers will be able to have access to a child or to the children that they both have. And so in seeking a Section 8 order, which the child arrangement order comes under Section 8, that means that you are asking the court to give you some sort of access or some sort of contact with your child, which involves where the child will live, how you can contact the child, when you'll be able to contact the child, if you'll be able to take the child on holiday, and the rest of it. And so it is to do with that child who is under the age of 18. So I should make it clear that it is only applicable to children who are under the age of 18. Once the child is 18, they can make up their mind as to which parent they want to be with in most cases. So this is applicable to children who are under the age of 18. And it's also important that as much as possible, we understand that there it's a step-by-step process. So of course, you are not only saying to the court that you just want to be able to have access to this child or to the children, but you're also saying to the court that you've tried other means of resolving it, not just through the court system. You've made sure that you have had some sort of informal agreement with the other parent. Of course, if the other parent is not forthcoming with the arrangement, most people would definitely have to try mediation before they even apply to the court. So if you've given mediation a try and they've said that they have realized that mediation is not an option for this particular issue, or to resolve this particular issue,
Yeah.
they will also give their certification for you to apply to the court for a child arrangement order. And in most cases, if the person was not forthcoming in the previous, should I say, informal ways of trying to reach an agreement, then they might be able to say that, do you know what, they are not going to give you a chance at all during the court process. And with the court process, of course, they would have the social services, and usually those social services officers will be Kafkas. So they have a special name of Kafkas, and those Kafkas officers will be the ones that will actually assess the parents. So not just the parent who is living with the child, but also the other parent. And then they will assess the child as well. So they will have to make their assessment and then make a report to the court. And usually the court will use this as a sort of guidance when making their decision in terms of how much contact the other parent should get, and what sort of contact the parent should get, and whether the child should even live with the other parent at all. And they consider things like whether that person is likely to cause risk or any harm to the child or to any other persons. And if they do have criminal convictions, and they obviously look at the person's total well-being and whether they will be capable of even looking after this child. So there are a number of different factors that they will consider. And of course, once the Kafka's report has been given to the court, they would then see how best to use that report in making their decision. And a lot of the time, like I said, if the other party is not forthcoming, is a continuous back and forth, should I say, role play. So let's remember that the court is also one of the most important bodies when it comes to our democracy. And so if you are given an order or a direction by the court to attend a hearing and you do not do so, you will be in contempt of court, and they can imprison you for that, which is a harsh consequence, but that is the case. And I was making an order for a client, and the other person was not forthcoming whatsoever. And so obviously we had to stress the fact that if they didn't come for the third time, they are likely to be imprisoned if they do not appear.
Wow. Okay.
And that in a way sort of made the person, realize that this was something that was serious. And so she was then able to attend court. But it's one of those things where I always say it can be a long process if the other party is not cooperating. And so as much as possible, you should be patient and have it in your mind that it can be a long process, and it will involve a lot of fees as well, because you're not just attending one hearing. It could be several hearings before a final order is made. So it's very important that we also put this in our minds when we are trying to apply for these child arrangement orders.
Okay. And I'm just thinking, what if the father is not on the birth certificate of the child?
Okay, so you would see that most of the time when you are making an application to the court, they will ask, or the form will request, if you have parental responsibility for this child. And most of the time, the law is very, should I say, good in terms of things like this. So somebody who is a mother, automatically the law sees that person as someone who has parental responsibility.
Okay.
And then if you were to say that you were not married and you were in a relationship with a person when the child was born, usually it is the case that if the child was not on the birth certificate, then they would like to see, the parent who is the father was not on the birth certificate, then they would like to see if for one reason or the other, this parent will have parental responsibility. And usually, as of the 1st of December 2003, if they were not married and the father is saying that for some reason he is not sure why he wasn't put on the birth certificate, but he knows that he is the father of this child, they can ask for the mother to make her consent known, whether she knows that the father is Mr. A, B, or C.
Yeah.
If she doesn't give her consent, and of course, they would ask for a DNA report to be done. And then usually that will then clarify whether the father is who he says he is. And in that case, usually that will also mean that the birth certificate can also be amended to show that Mr. A, B, or C is the father of the child. And in cases where, for instance, the child's father's name is on the birth certificate, for instance, then of course they would, of course, go by what the birth certificate says, and there shouldn't be any issues whatsoever. Where, for instance, we're not talking about parents and we're talking about other family members, then that would mean that the courts will have to grant that person parental responsibility for that particular child. But in most cases, even if the parent who is the father was not put on the birth certificate, they will, as much as possible, try and give that parent parental responsibility if checks are done and the other parent is not consenting to the fact that the father is the father of the child. And so it shouldn't be much of an issue. It might cost you, but it shouldn't be much of an issue in establishing whether that person is father to that child when it comes to the law. So yes, it's helpful when your name is on the birth certificate, but if it's not, then of course they can have that addressed by asking for the person who is the mother's consent. If not, a DNA report can be done, and then that can be established by the court that parent is the father, and therefore he has parental responsibility for that child.
Okay. Laura Eunice, when you were explaining to us the process, you made mention of mediation.
Mm.
Now, with the mediation, is it in the solicitor's office or can you have it in your church? How do you go about it? Is it only done in the solicitor's office? Because you need to get proof that the
Mm.
mediation had taken place
Yeah,
before going ahead with it.
with it. In terms of mediation, when I spoke about mediation, there's a special name that's given to it, and they
Okay.
usually call it mediation information and assessment meeting. And
Okay.
usually, people that are qualified mediators are the
Right.
ones that provide this service. There are some solicitors that are also qualified mediators, but not all solicitors are mediators. So there are a few that are both solicitor and mediators, but in most areas, there would usually be a mediation service.
Okay.
And most solicitors will be able to provide clients with these mediation services contact details for them to attend a MIAM, which is a mediation information and assessment meeting. So once you have been provided with their contact,
Yeah.
then of course you would be able to find out if they would be able to give you availability as to when they can see you, have a chat with you, arrange a meeting with you. And once they've arranged a meeting with you, they will collect the details of the other party. So if you have the details of the other party, who is the mother or the father, they will take those contact details and
Right.
then, of course, contact the other party to see if they can get to some sort of agreement. If you do not have the contact details of the other party, let's say because they've changed their telephone number and for some reason you don't know where they live, the mediation services will also be able to give their certificate in saying that you are not aware of the contact details of the other party, and therefore they believe that you can go ahead and apply for a child arrangement order with the court. And the court always has a way of finding these people.
Okay. Can a child arrangement order be used in obtaining leave to remain in the UK?
So, in terms of the law, which is our immigration law, so when you say that you are making an application to say you have direct access to this child, and that's in most cases a father who is applying for further leave to remain because for one reason or the other, they do not live with the child, but then they do have some sort of contact with the child. If that is the case, then of course they can apply to the court for a child arrangement order. And usually they will also have to request that that order can be disclosed in terms of immigration purposes when they are making their application to the Home Office. So in those cases, if you are making an application to the Home Office for further leave to remain, and you are sure that you have contact, and it doesn't have to be indirect,
Right.
because the immigration rules is quite clear that it has to be direct contact. So you should be able to say that you have physical contact with your child. So it's not that you are calling them on the phone or emailing them or having video calls. It should be physical contact where you see the child, where you are able to spend time with the child. And that's the sort of contact they want to see on that child arrangement order. So maybe a father is seeing his child for 2 weeks during the summer holidays, and then every holiday period. And so that in itself shows that that parent has direct contact with the child. And if that parent does have direct contact with that child, then it means that, of course, they should be able to rely on that when making their application for further leave to remain with the Home Office.
Mm. Right, ladies and gentlemen, if you've just joined us, this is the Legal Hour Show with BWF Solicitors. Today's topic is child arrangement order. Lawyer Eunice has taken us through the process and the circumstances behind child arrangement order. Um, please send in your questions, because when you bring in, send in your questions and get involved in the discussion, makes it very, very, very interesting. I would love to see that. So please do send in your questions on our Facebook page at BWF Solicitors. If you want to call live on this show, call me on 0744 7617811. If you call me, I'll be able to take your questions for Lawyer Eunice to answer them. Don't worry, at the end of the show, Lawyer Eunice will give you their office contact details and their out of hours phone numbers as well. But this number is just for today's show. Wow. And let me also remind you to also share, 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 share. Get your colleagues, loved ones, everyone on your contact to get involved. Sometimes, we don't know when certain situations will, affect us. When we first, advertise this topic, which was going to be discussed today, I spoke to some few people about it, and they were like, not me. I don't think I'll ever be in this situation. But, people who get into this situation didn't never thought that they'll come to that road where, there has to be mediation between both partners for child arrangement order. So nobody knows when you might need this, information. So let's all get involved, listen, share, 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 send it to all your contacts, let them gain some, knowledge from this, so that when it eventually happens, if it is not even you or someone close to you or someone at your workplace, you'll be able to, explain to that person, and if possible, refer them to BWF solicitors for help. Lawyer Eunice,
Hello.
the questions are coming. Hey, hey. Right. Um, this person wants to remain anonymous. I have been struggling for some years now to have contact with my daughter, who is now 8 years old. It was through me that the mother came into the UK. Things did not work out between her mother and myself, and it has now become clear that because she's in a different relationship, she will not have me have any contact with our daughter. What steps do I need to take so I can have some contact with my daughter?
Wow, that's a sad situation.
Yes.
So he's saying that, of course, this child is now 8. It doesn't explain when he lost contact with this child, but he obviously wants to try and make things right and form some sort of relationship with this child. And in most cases, in a situation like this, they would first of all need to try mediation. So if they do have the contact details of this mother, then they definitely need to attend a MIAM, which I explained before as a mediation and information assessment meeting. So once they've attended a MIAM, of course, if they reach an informal agreement and the mother says, do you know what, I will allow you to contact my child through phone. So if you buy her a phone and you pay for the phone bills, I will definitely allow you to call him once a week or twice a week, whichever um, case it may be. So if there is that sort of agreement between the two of them, then of course it depends on whether that person who is the father is in agreement with just phone contact. Maybe as time goes on, it will progress into some sort of physical contact as the child grows up, because we know that in the UK, children start to form an opinion after the age of 10. That's what sociologists say. So once they think that, you know what, at some point I want to go and see my father, some of them will start to make their own minds up and their own decisions in regards to whether they want contact with their fathers. And some of them can even do it without the other parents knowing. But I'm not advising that any child should do that. But in those cases, if they do reach an informal agreement, then of course they don't need to go any further. Where they feel that, do you know what, they need the court to give some sort of rubber stamp to their informal agreement, then of course they can say to the court, yes, we've reached an informal agreement. Can you please have it certified to say that this is something that we both agreed, and therefore the other person must abide by it. In terms of the other party not being cooperative, so where they think that, well, I'm in another relationship, I don't want you to see your daughter or have any contact with your daughter, or if the relationship ended very badly and they were not on talking terms when it ended, then it becomes difficult for there to be some sort of amicable solution. And so in that case, if mediation is not an option and they've tried it and it's something that cannot be used to resolve the issues that are at hand, then it will be much better for the father to apply to the court for a child arrangement order. And usually, once the application has been made to the court, of course, they will need the contact details of the other party. I was saying before that I previously had a client and he didn't have the contact details of the other party. And so usually, once you fill a C4 form and you tell the court, I don't have the contact details, but I know the name of this person, the date of birth is likely to be so and so, previous address is so and so. They have their ways and means by which they will be able to track this person down and contact this person. Because as you all know, we have a system in this country where every child who is under the age of 16 must be in school, and every local authority has the name of every child within their authority. And so they always have ways and means of tracking parents down. So yes, of course, once you've completed a C4 and you've given it to the courts to track this person down, then they can make contact. And in this person's scenario, he already may have contact details of the other party, who is the mother. And if they go through with the child arrangement order, then that would mean that he needs to be prepared for the cost involved. If he's, representing himself, and most people may not want to do so because of things like bundles and preparing the position statements and other things that most, should I say, lay people would not be able to do by themselves. Even very educated and understanding people sometimes struggle with it. So in most cases, people will seek legal representation in doing so, so that as much as possible, the burden of preparing and doing the paperwork and the rest of it doesn't fall on them, but rather will be on the legal representative. So once they've decided to go ahead with it, there will be an opportunity for the other side to also present their case in a position statement. The CAFCAS officer, who is also a social worker, would then assess both parents and the child or the children involved. And then they will take it from there. Some parents can be very stubborn. They wouldn't want even CAFCAS officers to even interview them or even interview the children. And obviously, all of those things will be things that will be addressed to the court if the other parent is not forthcoming in the whole process of making the report. And so these are also part of the things that cause delays and prolong the process. And as much as we want to say that getting a child arrangement order is the best thing, you should also be aware that it can be a very long process, a process that is demanding, and you may also find it to be costly, because once you attend a hearing and you have to pay for legal representation, that in itself is cost. And then you also have to pay for any sort of court fees in terms of when you're making the application to the court as well. So all of these things put together make it a long process, but also a worthwhile process if you are able to have that contact that you want with the child. And in his case, if he's looking to form a relationship with his child, then of course, going through the process will also at least give him a chance. Because when you have a child arrangement order, if the other party doesn't abide by it, you can always go back to the court and say, this person is not abiding by the order that was granted, and therefore you want the order revised, or you want the other party to be forced in some way to go by the order that was given. And in most cases, the court will respond and they would give the other party an order, or they would let them know that this is what has been said by the other party. Is it true? And obviously, you have to defend whether you have given that person the opportunity to do so or not. So that is also another advantage of having a court order rather than an informal agreement, let's say.
Right. Laura Eunice, whilst answering this question, you made a comment that children from the age of 10 have an opinion. Now, when there's this situation whereby you also made mention that usually the child stays with their mothers.
Yeah.
Now, during mediation, the child is 10. And mom believes that the child should stay with her.
Yeah.
The child goes like, I don't want to be with my mom, I want to be with my dad. Now,
Mm,
that child's opinion,
yes.
the final decision.
Of course not. So let's let's look at it in perspective.
At 10 has an opinion. So I thought,
Mm,
if the
the
child is
child's
saying that
opinion
I want A, I
cannot.
don't want B, they have a child that, oh, yeah, the child has said it. So let's go with what the child is saying.
Of course, the child's opinion will be considered because in drawing these different factors, the court has that responsibility of looking at the child's age and considering the child's best interest as well as what their needs and wants
Yeah.
are.
Mm.
So if they're looking at all these things in regards to the child, they are looking at the fact that, well, this child is 10. If the child was 18, then of course that's a
Okay.
different
Right.
position. But
Right.
because this child is 10, they're going to look at what's in the child's best interest.
Yeah.
Is it better that this child stays with the mother because they're already enrolled at school, they have friends at school, that of course they would not want to move school just because they want to live with their father. And they will also consider the fact that of course if the child is with their mother and their mother is usually maybe a part-time worker, she will have more time to spend with the child, whereas the father is always working and the rest. Then they will consider those things as well. They will consider, of course, the fact that maybe this child has other siblings, and it will obviously affect the child emotionally if the child were to move to another place with just the father and not have any contact with the siblings and the rest of it. So all these things will have to be considered. And so it's not just what the child's opinion is. Fair enough, they will consider what the child's opinion is, but they will also look at other factors, like I've just mentioned, how available is the father, for instance, and they will look at the capabilities of the parents who would have the time for this child, who will be able to obviously take the child to school, pick them up, do the other runs if, for instance, the child has to go for extracurricular activities and the rest of it. So they will consider things holistically and not just the fact that the child has said they want to live with their father and therefore that is the end of it. It would be so good if the child could have a say and their say was final, but the court will also have to consider all these other factors. And so, yes, once the social worker or the CAFCAS officer has made their recommendation, of course, they will put in there that the child says they want to be with their father for A, B, and C reasons, because you need to find out why the child wants to be with their father and not their mother. Is the mother abusing them in any way? Is it sort of toxic in the house? And they will have to consider why the child is saying that in the first place. If the child is only saying that because they think that they don't like their mom and they prefer their dad, that will not be sufficient for the child's opinion to outweigh all the other factors. So yes, they will consider it, but it will not be the final say.
Right. Ladies and gentlemen, I would have to correct the number I gave for you calling live on the show. I think I move some of the numbers around incorrectly. So my sincere apologies. The correct number to call us live on the show is 0744 8619 711. 0744 8619 711. Get involved in this discussion to make it more interesting. Lawyer Eunice, to add to what you were just explaining to us regarding the child's opinion, this last thing I wanted to ask, if the mediators are not aware or the other party is not aware of any abuse going on, and the child mentions, I don't want to be with mom, maybe the child abuses, the mom abuses the child with no one knowing. Do you think they would have to interview the child, really find out what are your reasons? Are you happy? If you are happy, why are you unhappy? Now, when it comes up that the child is being abused, would it overturn whatever decision they've taken, taking into consideration, like the
Yeah.
decisions you gave us?
Yeah, I think that in terms of the child being abused, let us remember that most of the time these children go to school, and within the school system, you can speak up to your tutor, I mean, privately, and say, do you know what, this is what is going on at school.
Mm.
So if the Kafka's officer is speaking to the child, because of course during these interviews, most of the time the other parent will also be present. And so if they are not able to speak up because maybe the other parent is present, then it might be the case that they need to start raising the red flags at school.
Okay, right.
And so most of the time, if they see that there are certain signs that they look out for as social workers, and if there are some signs that sort of show that the child is not interacting the way that they should, and they feel that the child is not opening up, they may also look into other agencies such as the child school and assess from the child's should I say behavior at school, whether they're a child who is outspoken or usually quiet, and if it's part of their normal day-to-day activities that they are quite reserved, because there are some children that are reserved and may be shy and the rest of it. But if the child feels they cannot talk to the Kafka's officer who is present with the other parents, some of these red flags will be shown at their schools. And most children know how to sort of show these things, or tutors are very good at also picking up on these things as well, because they are trained to look out for certain signs. And so if there are any red flags, I believe that that will come up as well.
All right, great.
Yeah.
Great. Let me quickly acknowledge those who are on Facebook watching us live. I've got Louisa Santiago watching us. Louisa, thank you so much for your continuous support. I also have to say hi to Nana Bob. Hi to Bexma Kwesi Adams, Tilly Duma. Yes, and I think Perpetual has a question, but it's not related to the topic. So what I'll say to Perpetual is that let's finish with what we are to discuss today. And if Lawyer Eunice has any few minutes to spare, she may answer the question that you have. So just hold on there. If not, we will give you Lawyer Eunice contact details to contact her, during her office hours, and you can access those questions and, if possible, offer further help. As usual, share, and get more people involved in this discussion. Lawyer Eunice, my next question is coming from Anna. 3 years ago, my ex-partner and I had a boy. Before he was born, he started having issues in the relationship, and she will say things like she won't have any name put on the birth certificate, and so on and so forth. A month after the child was born, she asked me to leave and chuck my things out of the house. Oh no, it's not part of the apologies. I just empathize with him. It is very upsetting, but I left. I was previously given leave to enter as a spouse, and I want to know how I can go about applying for further leave to remain. Sometimes I get emotional about questions, so when I get, I don't know.
So this is some of should I say the situations where you have person coming, they are in a genuine relationship.
Mhm.
It is not something that they were looking forward to, like you were saying at the beginning. You do not ever want to be in such a situation, and you find yourself later on coming into a situation like this, and that makes it very difficult for you because you are thinking, I've come to join my spouse and I want the relationship to work out. We want to have a family. You end up having a family, and then, of course, this happens. So, of course, in a situation like this where the other party is not sure whether they are on the birth certificate or not, of course, they would need to find out as much as possible whether they are. And as I've been saying, before you even try and make contact with the court, you need to be able to show that you have attended a MIAM, which is a mediation and information and assessment meeting. If you are able to show that you've attended a MIAM and you are showing them that as much as possible, with the contacts that you've had, you are not able to establish whether your name is on the birth certificate or not, they will contact the other party and they will try and find out as much as possible from the other party. And they don't need to physically meet with the other person. Having a phone call or sending emails can be a way or means by which they will be able to get further information or contact with the other party. And so in that case, I would say to this person, as much as possible, give mediation a try, see how far you get. If you are not able to get very far because this other party has made up their mind, they don't want you to have contact with your little boy, then you can go forward and apply to the court for a child arrangement order so that at least you will be able to have some contact. When a child is that young, it is very important that they have the other parent in their life so that they are able to have that guidance that the other parent will give.
Okay.
I'm not saying that single parent families are not doing a good job. Of course, those that find themselves within a single parent household are doing a brilliant job. And you will see that the usefulness of both father and mother in the household makes a difference. And so, of course, if the other parent is in the life of this child, it could be that they may be able to guide the child in certain ways that the mother may not be able to. And so, of course, they would consider these things when making their decision in terms of a child arrangement order. And like I said, Kafka's will also have their report done, and they would definitely have some sort of contact with the child to assess the child in terms of when they're making their report. So it's important that as much as possible, if this parent doesn't form or pose any risk or harm to either the child or his ex-partner, then they should be looking into giving this father direct contact with his child. It may not be a full day or sleepover because he's only 3 years old, but at least it will be some sort of contact where he's able to spend some time in the park, for instance, with the child, or go to McDonald's or whatever on a weekend, or let's say during school holidays. And then as time progresses, it might change to much longer contact. And one good thing about these orders is that it can be varied. It doesn't have to stay the same forever. You can always have it varied from one thing to the other. So, of course, he should give it a go. And once he is able to get the child arrangement order, then he can rely on that direct contact with the child to make his application for further leave to remain. So, as long as he's able to show that he has direct access to this child,
Mm.
which is physical contact with this child,
Yeah.
then he can rely on it to make the application to the Home Office.
Okay. Okay. Brilliant.
You
Brilliant.
were saying there was a question, isn't it?
There was a question for perpetual, but that's not related to the topic we are discussing. So probably, I think I'm on my last question. If you feel you want to answer perpetual's question, that's fine. But she's also, acknowledged that it's not related to today's topic. So it's your own decision. So let me quickly read the last question. Lawyer Eunice, I help to take care of my sister's children. Can I apply for a child arrangement order to further my leave to remain in the UK?
Interesting question.
Mm.
I think that with most relatives or family members, if let's say the mother or the father is having some sort of let's say mental breakdown, and they are not capable of taking care of the child,
Mm.
and it falls on a relative to be able to take care of this child. So in this case, they're saying they're a sister. So in this case, this sister has been taking care of this child sometimes because unfortunately the other parent is not capable of taking care of this child. If that is the case, then of course they will be applying to the court for a child arrangement order and also applying for parental responsibility to be given to them so that they can continue in their role as auntie and carer to this child.
Mm.
But where you have, let's say, a father who is capable and also has parental responsibility, they will have to consider what the father's say is in all of this. If it's such that maybe the father is okay, but he thinks that he wouldn't have time for the child, he really does not want to be involved in this child's life, then of course they can consider the fact that this parent does not want to be involved in the child's life, and therefore they will give that responsibility to the auntie to be able to care for this child and then give them a child arrangement order. So it's very important that they know why this auntie is applying for a child arrangement order. It's not automatic that she can do so. She will definitely have to show what the circumstances are for both parents, and if they have given their consent that this auntie should be given the child arrangement order, or she should be given responsibility for the child, then of course they can go ahead and then consider the should I say the views of both parents before giving this auntie the responsibility for this child. So it is possible, but it's one that you have to be able to show
Mm.
clearly why the other parent cannot um, obviously take care of this child.
Okay. Someone has just sent me a line in relation to what you're saying.
Mm.
He's saying that it's child arrangement order same as adoption with what the this last question
Okay.
the person is saying.
Saying no. So adoption is completely different. In terms of the child arrangement order, I was saying at the beginning that is an order made by, I mean, the courts to be able to know when the child is supposed to have contact with you, where the child will live, how the child should be taken care of, and uh, who is responsible for making some of the important decisions in the child's life. That
Mhm.
is not the same as adoption. Adoption, of course, will be an order given by the court so that you can
Yeah.
have the full parental
Parental
responsibility for this
responsibility.
child, and then this child will be in your sole custody. So
Mm.
it's not as if you are sharing this child with any other
Yeah.
parent, or you're sharing this child
Yeah.
with any other person.
Yeah.
You will have that sole custody of
Mm.
that child, and
Mm.
you will make all the important decisions in this child's life, and the child will be able to obviously live with you as a parent or parents when you make the adoption order. So adoption order is completely different to a child arrangement order. Where child arrangement order is when you have that shared responsibility with the other parent, but with adoption, it is only for that sole purpose of you having that child for the rest of their lives. So even after the age of 18, this child is your child.
Your child. Oh, okay. All right. All right. All right. So, ladies and gentlemen, if you've just joined us, this is the Legal Hour Show with BWF Solicitors with your host, Vicky Newton, and our resource person, Mrs. Lawyer Eunice Achampong, who is a solicitor and one of the partners at BWF Solicitors. And today we are discussing child arrangement orders. Lawyer Eunice, I think I'm done with my questions. If you like to answer some few questions, which, as I said, are not related to today's topic, it's up to you. I think 2 questions have
Okay.
popped up. If you would like to do that quickly.
Okay. So I know there was Perpetual.
Perpetua and just now Frederick Ansu. So you
Oh,
can
okay.
Perpetuals first.
Okay, so Perpetual says, hello, lawyer. My question is not about the topic discussed today.
Yeah.
The question is someone coming from Ghana with a spousal visa, which English test does the person need to take in Ghana in order to come here in the UK? Is it IELTS or A1 or B2? So when you're making a spousal application, you have to meet the English language requirement, and they expect that you'll be able to do the IELTS at a level A1. So that person needs to be able to take an IELTS test at a level A1, and that is the requirement under the immigration rules. So I hope that answers Perpetual's question.
So we go to Frederick.
Frederick, okay.
Yeah.
Okay, so Frederick answers, he says, please, Lawyer Eunice, mine is also not related to today's topic. Please, can I go on holidays to the United States with leave or permanent leave to remain? I came here through my mom, who is an EU citizen this year. So, of course, if he was granted pre-settled status or he's been granted indefinite leave to remain as of this year, of course, as long as you have lived to reside in the UK, you can travel to any other country and come back because you have residence in the UK and you have been given a leave to be able to remain in the UK. Of course, if you are not a national of the United Kingdom, you will have to apply for a visa. There are some exempt countries, but from what he's saying, he said he came from Ghana. So I'm guessing that he would definitely need to apply for a visa to be able to go to America. So he needs to check what the requirements are, and then he can apply to go to America whenever he wants to.
Okay. So if he is a British citizen, would he still apply for a visa?
No, he wouldn't apply for a visa, but then I think there's the certification that you have to apply for, I think 48 hours before you go. And so once you're a British citizen, you need to apply for that before traveling to America. Yeah.
It's a bit confusing, especially when we are out of the EU as well. So
I know.
you pick your passport, book a flight, and you are off.
And just go.
You need to get visas.
I know. So even British nationals, you need to fill that certification before you can go. So it's all part of the process. Yeah.
So I hope, Frederick, your answer has been, your question has been answered. Perpetual is satisfied with the questions you've given her, and she says, "Thank you, lawyer." So, in the absence of any further questions, Lawyer Eunice will give us her contact details. But before I do that, Every Saturday, as I always say, BWF Solicitors do have a community and the law program every Saturday, 4 p.m. to 6 p.m. on their Facebook page at BWF Solicitors. Today's topic is fee waiver for immigration applications, getting it right for the first time. So I will entreat you to join in the discussion. If you have any questions, join them at BWF Solicitors, 4 p.m. live. The guest is going to be Charles Asma, and is Mr. Oriku hosting the program. So please, let's join them again, BWF Solicitors, at 4 p.m. on their Facebook page, BWF Solicitors, for today's community education program. Topic is fee waiver for immigration applications, getting it right for the first time. So on that note, Lawyer Eunice, if you'd like to give us your contact details for anybody who wants to come and see you for further advice.
Okay, and so as Vicky mentioned earlier on, I'm Eunice Champong, and I am one of the solicitors at BWF Solicitors, and we are located in London. Our offices are situated on the 4th floor of Anna House, 214 to 218 Tottenham High Road, London. The postcode is N154NP. So N154NP. And my contact number is 075 3581 3910. So my contact number out of office hours is 075 3581 3910. And if you want to obviously give us a call during the working week from Monday to Friday, our office number is 0208 493 7340. So 0208 493 7340.
Laura Eunice.
Hello.
Someone has just dropped in a question. I don't know whether we should break protocols. We just rounded up the show. So should these people call you to get you to answer, or you just...
They can definitely give me a call and I will respond.
Of course. So Nana Bob, please, you are very, very late. I know this is a USS question, but please contact Lawyer Eunice on office line 02084937340 or 02081231016, or you can contact Lawyer Eunice out of office hours on 075 3581 3910. Nana, please call Lawyer Eunice and she'll be able to help you with the question you've just asked. On that note, let's give Lawyer Eunice a little break. She needs to be with her family. Lawyer Eunice, thank you so much as usual. We do appreciate you taking time off your busy schedule to come have a discussion every Saturday 12 noon. We don't take it for granted, and our great gratitude to BWF Solicitors as well, making it possible for us to come your way again. We'll see you again next week, same time at 12 noon with another interesting topic. Until then, take good care of yourselves, enjoy the weather, and stay safe. Bye-bye.